Well, I think absolutely delighted and honored, I would say, to have with us here today Josh and Nadia, the two lawyers who were involved. And in case you don't recognize her, this is Natasha Wilson, the daughter who was here, testified before the Parole Board. And this is Mark Cohn, who had spent many years with the DA's office in Suffolk County and is now a Court of Claims judge, but sitting in county court, handling a lot of criminal cases. So I thought that perhaps we could start the discussion by asking the lawyers who made the film, what do you think the lessons are for students with your experience? And perhaps if you want to focus particularly on students in their study of criminal law, what are the lessons that this whole process shows, do you think? Gotcha.
I can project pretty well.
Right. Hello, this works.
Okay. You know, one of the lessons I think that is probably intuitive to you. I understand that Touro is one of the very few law schools in the nation that actually has a pro bono requirement for graduation and has for many years, for decades. I think that, you know, a lot of times as you kind of, maybe before you go to law school, you have a sense of, oh, lawyers can do really amazing things. But often by the time you're done with law school, you're sort of focused on, where am I going to get that offer? I've been summering somewhere. Where's this job opportunity? How am I going to repay this crippling debt, or whatever else your concerns are? And that for us, we really learned that as lawyers, we have this really very unique mastery and monopoly of skills and of knowledge and abilities that can have a profound effect on someone's life. And you don't necessarily even realize that. I think in the beginning we just sort of thought, no one knows what they're doing, and we don't either, you know. But as we went through this process, we really realized that we were uniquely situated to really change and affect people's lives. And I think that is all too often not echoed and is not loud enough in the world, and that we really have to remind ourselves of that. So I guess that was sort of the lesson, and I would kind of want to impart that to you, that if you really can kind of keep up incorporating the pro bono spirit and ethic into your practice, that I know for me, I wasn't expecting that this pro bono case would be sort of the most rewarding, the most important case that I would work on in my 8 years at a major law firm, but it was, and it still is to this day, of course. And so I would really encourage all of you to sort of keep that in mind and pursue that.
But could I I'm sorry, before we go to the next response, if I can just say, sort of not responsive to the question I was really asking, which was, what are the lessons about the criminal justice system that comes from all of this, do you think?
Well, I think for Nadia and I both, there was a lot of hard lessons, which is that a system, at least the one that we were up against, as broken as it was, and we saw in Debbie's life that she was sort of systematically failed at every stage, from the time she was 15 to the time that she died. One of the lessons that I was able to take out of it is, even in such a system where you can become sort of cynical and jaded and really, quite frankly, depressed, that throughout it there were individuals who kind of shone like gems, who despite their marching orders or despite the policies of their office, they kind of did the right thing because they were righteous individuals. And you saw the alibi memo, that was ultimately leaked to our legal team. Our private investigator was able to get that, not simply because he was amazing, but because someone leaked that. And we were able to have sympathies and courtesies along the way from prison guards, from staff in the parole board, even from different places where people sort of intuitively understood what was just and what wasn't, and were really willing to sort of go beyond the scope of their employment or whatever they were supposed to be doing to kind of help further justice. And I think that was really inspiring. And at the end of the day, quite frankly, that was one of the few things that was inspiring for us about the system and about the practice. And of course, we ultimately got a judge who was able to sort of see things the way we were, which was kind of some residual merit in the system. But at the same time, I think, quite frankly, it was pretty discouraging, and it wasn't really until this movie came out and we got to have hopefully positive reactions like you had to the movie, where we kind of got to see, okay, well, maybe sometimes the court of public opinion gets it a little better, than, quite frankly, than the way the judicial system does. I don't know if that's responsive either, but.
Let's see, is this on? All right. I guess the only thing, I totally echo everything that Joshua said, and on the first point, I will add that I think while in some respects it looked like we were uniquely situated to kind of take on this case, what I would say as well is that you have to be confident in the fact that, and I think Josh has said this too before, that particular for a lot of pro bono work, it doesn't necessarily matter if you're an expert, and the reality is you're probably not going to be, and that should not stop you. I think particularly when you're in law school and when you're, we were first year lawyers, you feel totally inept in so many ways. And it's just critical to understand that even if you are in fact inept, as you saw, we were. I mean, we failed repeatedly throughout the course of this journey. But what was really important to us was to understand that whatever it took, we were going to be there and we were going to support Debbie. And if nothing else, we would keep going and we would learn as we go. I mean, I think the question was asked, what did we learn in criminal procedure that was useful? I mean, I took a lot of what I learned from Law and Order to kind of move us through the process. I mean, you just don't know, and you kind of go day by day. And I guess the biggest lesson that I always try and impart to folks is that you don't need to be an expert in anything. You just need to want to reach out to somebody else and say, you're valuable enough that I want to fight for you. And with that, you will garner the support and the wisdom and the energy to move forward when everybody comes together and works collectively. Because that's really what happened in our case. I mean, you see Joshua and me up on the screen a lot, but there were so many people that were absolutely critical to making this case happen and to supporting us along the way. And I mean, our family is here today. Our family got us through on those days when we didn't want to get up in the morning. As Joshua said, we had so many people inside the system who kind of continued to reach out and show us the way. So it was an amazing process. So like I said, look for those opportunities, and even if you're scared, just do it anyway. It's kind of, I guess, my big lesson.
But if I can just follow up a bit, I was taken aback towards the end where after we see all of this misconduct and all of the attempts which were so futile, and then you say, directly speaking to the camera, that if she doesn't get out at all, then sort of the whole system's rotten, but if she gets out even just for one day, then what?
Well, I think it highlights the opportunity that all of us have to achieve something powerful if you don't give up. And that's kind of what, the point about the criminal justice system and what we learned, what we saw is that there has to be accountability. I mean, it was frightening to us that we had so many resources, we spent so much time, we had basically the best factual situation once we developed it over a period of 3.5 years. But we had all of these pieces that should have been a relatively easy ticket out for her, and yet it was incredibly difficult. And what we kept learning was that the rules just don't apply in this system. I mean, the story of Zabrina going to the parole hearing, we worked to get Zabrina, his sister, at the parole hearing. And when we were advocating for her to just be allowed into the room, the person on the phone said, "Oh, I'm sorry, why is the defense attorney calling?" We said, "Well, she's here on behalf of the inmate." And they said, "Well, I'm sorry, I'm just not inclined to let her in." We said, "That's irrelevant. The penal code says that she has an absolute right to be here." And she said, I'm sorry, I'm just not inclined to let her in. And it took 5 hours of Joshua and I sitting in a parking lot saying, oh, you're going to let her in, one way or the other. And eventually she was. But
They never had anyone refuse to leave prison before. That was our trump card, as we said, if you don't let the victim Oliver Wilson, if you don't let his sister testify, we refuse to leave this prison. And so they had to like call Sacramento. It was very confusing. Like, well, they're not leaving prison.
So I think, I don't know if I'm, again, being responsive, but I think what was important to me was to help folks understand that that Debbie could serve as an example of how you can make a broken system still work and result in justice if you keep pressing forward and if you work collectively.
Judge Cohn.
I would also add several truisms. Nothing that's worth it in this life comes easily. And second, a famous person once said, if you will it, it is no dream. These two lawyers spent literally the better part of 8 years fighting for a cause. Each of you will be given what is the most marvelous thing, hopefully, some this coming June, some the following June, and that is a license to practice law. Many of us will do with it as we will. Many of us will make a lot of money. Many of us will gain creature comforts. There are a few who are willing to do what both Joshua and Nadia did, and that is work to, in essence, better the system itself. The overarching concerns that are expressed in this movie cannot really be gainsaid. I mean, the movie expresses what is plain. First, for the prosecutor to obtain a conviction, they have to, quote, prove the defendant's guilt beyond a reasonable doubt. Here, obviously, that process was perhaps complicated, and that's a nice word, by what happened in order to obtain that guilty plea. The difficulty then is to, quote, get somebody out is literally a switched playing field. Instead of the prosecutor having the burden of proof, the burden rests, obviously, with the defendant in some fashion. And there are many procedural vehicles, but in plain words, what you saw here was, at some very trying moments, certainly for this team, the system at work. And I'm in no way defending what happened. But in simple terms, it's, quote, the prosecutor's burden to, in essence, prove guilt beyond a reasonable doubt, and then the burden shifts, literally, because the presumption is literally evaporated, and the defendant is no longer presumed innocent, in this case, of course, guilty, until it can be demonstrated that there's been some, quote, wrongful conviction. And I don't presume to understand California law, but California has a process of what could be called collateral attack on a conviction by way of state habeas corpus. We actually have a state habeas corpus statute that is of no use in this context, but we have other procedural vehicles that could allow for, without the specificity of the California law, a similar result. But I'll end where I began. The perseverance and dedication is beyond shocking. And it's a lesson for everyone. Because in simple terms, again, if you will it, it is no dream. And also, you have to be willing to put your money where your mouth is. In other words, it's easy to talk about, I'm going to do good for the world, and maybe we'll all feel that way when we get to our graduations. It's the day after, the week after, and of course the years after, that is the real lesson.
But Mark, those who are my students who are here sort of know that I very often think the best way that we all learn is by challenging comments that were made, so don't take it personally. But you said, I think what you had said was what we saw, how we saw the system work.
Not very well, but we saw it work. And in simple
We saw it work. Yeah, we saw it.
work. But I think the point is, the system is flawed, as it evidently was in California, at work. And the point is, it is not an easy thing. And I think I'm understating it. When I'm looking at the lawyers, and I'm looking at Natasha, and I'm saying that system worked at great cost and human cost of 8 years. And what's the point of all this? Sometimes it doesn't work very well at all. But the point is, as lawyers, you're given the most marvelous of abilities. You're given the education, the tools, and in essence, the understanding. And for whatever you don't know, or they didn't teach you in law school, we learn along the way.
I mean, I will say that, as you know, the system worked, and our job is we get to force it to work better through advocacy. And I'll just note one other part that you don't see very much in the movie, but it's raised a bit. But it was a similar sort of advocacy that you all may get to take advantage of one day. You know, when she became very sick, the other piece of this is that there was no support for her in the prison to get well or to even stay alive long enough until we could get her out. And so there was, again, there is a system, and yet there were constant obstacles to her getting, I mean, we had to threaten to sue just to get her diagnosed, let alone anything else, to get her treatment, to get her pain medication, to allow her to walk, what they say, she had to get a permit to walk to take a shortcut because she was in a walker. You had to constantly advocate for her, and there was an obstacle every single day, and yet what you realized is, in part because we came from a big law firm and we had good letterhead and we could threaten, that was effective. But the other piece that became effective as well is we began to develop all sorts of creative workarounds. And so we realized that in the system, it's all about communication. And so folks in that system every day secretly called somebody in our office, either a correctional officer or an inmate, and told us what was happening. And then we figured out the system again, who to call and who to fax, and we started faxing. I mean, we had, I don't know, 30 letters a week sometimes saying, this is not happening, this is what's supposed to happen. And we would fax them across the state. And then we'd get follow-up hours later, and we'd get confirmation that she got her meds, she got, was taken to Madeira, whatever else. And so it's part of figuring out how to use your legal skills to force the system to work to the best of its ability, and also realizing that you're all going to be lawyers, and lawyers are fighters, and lawyers are creative, and lawyers typically persevere, and those are all the kind of skills that are going to come in handy when you're serving as an advocate. So you don't have to just focus on what you learned in your books or what statute you can point to. You can just press, and eventually people just say, gosh, all right, just go away and we'll do it. And so that also will come into play.
What happens here? In criminal law, again, we study the import of all the time of deterrence. What here serves as a deterrent for DAs in the future to not engage in, and your words were very strong, both Nadia and Josh's words were very strong during the course of this film, about the misconduct of any number of ADAs and perhaps the DA of Los Angeles here. What happens to them? What's to deter repeated misconduct and tolerating witnesses on the stand lying and not turning over material that's required of prosecutors under the Brady versus Maryland rule to the defense counsel? Because there was no civil case here, you said. No civil
right, there wasn't a civil suit, and quite frankly, the wishes of Debbie's family were part of that, but the other part of it was America really has an amazing, I use that in terms of a neutral sense, set of prosecutorial immunity laws, right? And the idea is that, well, a prosecutor really needs to have the freedom to be able to do their job without worrying about being sued for money damages later on for being too aggressive or for making a mistake. So they're shielded from that. And the remedy that's provided, at least in California, is supposed to be, well, the prosecutor sort of gets off, gets to keep doing their job potentially, but that the criminal defendant gets to have evidence suppressed or gets to have their sentence reduced or to be released, et cetera. And I think that it doesn't work very well, at least in LA County, in part because the parts of the judicial process that you don't learn about in law school. Just one example was, and I'll get back to your question, but one example, we hired as a consultant a former DA, a senior DA from Steve Cooley's office, who said, when we kind of had this alibi memo and everything else, he said, well, why don't you go talk to the judge about this? And we said, well, what do you mean talk to the judge? Like file a motion or what? No, just go talk to the judge. And we said, well, we can't have just like an ex parte communication with the judge. And he said, oh, no, you go down to 210 West Temple in LA and the cafeteria, everyone's there, the judges, defense attorneys, DAs, you just catch them in the cafeteria line, just show it to them, talk, hey judge, we have this, is there a disposition we could work out, you think? And we said, well, we're pretty sure that we're barred by the professional responsibility rules from having this communication. And he said, oh, that's just a civil lawyer thing. In the criminal world, it's totally different. And we reviewed that and decided that no, the rules they weren't different, and we weren't comfortable doing that. But apparently, that was just what was, So we were sort of at a disadvantage. But I think, I hate to sound sort of, again, kind of extrajudicial, pun intended, but ultimately, I think the deterrent here for prosecutors were one, the fact that Steve Cooley lost his race for Attorney General by 65% in LA County, which was the place where we were bringing all of our political and media pressure on him. So I think that was sort of part one. Part two is he did not run for re-election, and he is, as of January 1, being replaced by an African-American woman Democrat as the DA. And I think part three, which is perhaps the most important part, is even though, interestingly, Debbie's case is not precedential, it is not part of the stare decisis, it is not a case that people will be able to cite in pleadings, etc., the women who have come since Debbie in LA County are very quietly being fast-tracked and given justice and getting out. Because I think that the trouble that we stirred up for the district attorney's office was such that they realized that they had made a mistake, even though they wouldn't concede that. And for example, we were shown at the Los Angeles Film Festival, which, as you can imagine, is a big film festival. And every year they select one movie to show at this massive outdoor amphitheater that's 2 blocks away from Steve Cooley's office. And so when they showed the movie, our movie was there, they selected our movie to be shown there, and they publicly invited the district attorney to sit on a panel with us, just like this. And Cooley was forced to write what must have been a very uncomfortable letter, which said, I refuse to see this movie, I will never see this movie, I will never be on your panel, and I refute everything that's in the movie not having seen it, or something to that effect. So I think
Assassination, killing for hire.
What's that? Right, and she was a cold-blooded assassin, So I think that, I guess one way of looking at it is there's all these sort of crazy extrajudicial things that shouldn't be taken into account. Another way to look at it is what you learn about being a lawyer in law school. I don't know how your law school is, but certainly in our law school, they didn't prepare us for any of this, but those are arrows in your quiver. As a good lawyer, you need to have maybe a good PR consultant. You need to be able to have a good lobbyist. I mean, this is part of being a lawyer. And for us, and now I'm sort of, interestingly, at a government agency, and I use those resources all the time. Okay, well, let's have someone plant an editorial about this, or whatever it is. It's just part of the package, and you need to have sort of a more holistic approach to lawyering to be able to get that that deterrent effect or that sense of responsibility sometimes.
Natasha, I can't imagine how difficult it has been for you in all this, being the daughter of both the defendant and the victim here, and maybe if you can speak in general about that, but then in particular, perhaps, how hard it was for you to testify before the parole board, as we saw towards the end of the film.
It wasn't hard at all, even though, yes, it was my father. That was a little challenging going forward, the beginning of it. But the stuff he did was not justified. It was not okay. So it doesn't change the fact that it wasn't okay because he was my father. So going forward, I had to learn how to deal with that and separate the two. It was very difficult. But when I stood in front of the parole board, it was me pleading for my mother. My father at that point, he's been gone for a long time. It was no going back, and it was nothing that we can do to bring him back. I needed to get her out. She was still living, and she was incarcerated illegally. She shouldn't be there. So it was very easy for me to do it in the sense of I'm supporting my mother. It was hard because I'm sitting here so emotional, like really pleading for these people to just let her out when I don't feel like she should have been there in the first place.
Were you asked any questions by the parole board?
Was I asked any questions? I don't know. I wasn't. They just asked me to speak. She was real forceful for me to speak and tell her how I felt, but she never asked me anything.
And I wonder if this isn't revealing any attorney-client privilege, but we do talk in class again about just what factors parole boards use in determining who's going to get paroled, and certainly the person who wants to get paroled being very contrite. I do understand this is the wrong that I did, and I understand the repercussions of that, and that's exactly here what's said. So could you just speak to that a bit?
Yeah, I mean, at we had a fascinating process because we went through the parole process many times and were denied many times. And I think that, at one of our hearings where I thought we did a really compelling job of presenting the case, at that time, before Debbie was sick, the parole commissioner literally said, with a case with murder like this, she just hasn't been in long enough, which just wasn't amongst the criteria that we were presented, but that they were sort of showing us their playbook, which to us signaled that maybe in a few years, if everything's the same, then it will be okay. But they obviously had some sort of benchmark that they were using. The other thing that was fascinating was that the parole commissioners, when you looked at their biographies, in the pre-Jerry Brown parole commission, because it's changed a bit now, but they were all, former correctional officers, former sheriff's deputies, no one that would, maybe a psychologist or someone who would be familiar with the rehabilitative process or anything like that. So that was a little surprising. And I think there was this real disconnect, and I'll get to your contrition point and let Nadia jump in, but they very much, especially in the beginning, kept saying, well, we're denying her parole based on the severity of the commitment offense, meaning the brutality of Oliver Wilson's murder. And we kept sort of highlighting, right, but she wasn't involved in that, she didn't want them to do that, and even if she had been, it wasn't like, I want you to do it like this, even if you believe the DA's story, there wasn't this sort of, the callous, dispassionate, and we're like, well, that even, and interestingly, if you actually looked at Debbie's plea, she actually didn't even plea to any of that. It was a very sort of odd, generalized plea, which the DA had obviously allowed her to have because they were really trying to avoid having to prosecute her case because they ultimately didn't have any evidence. So they were sort of stuck reading these cue cards, and it felt like it was just sort of a one-size-fits-all for us. And then absolutely, I mean, just from everyone that we talked to and everything we can see, even though there was no per se express requirement that you must be sorry that you did this horrible thing, we just understood that must happen. You must be sort of cop to what happened and express regret and remorse. We were fortunate in a sense that Debbie, throughout it all, even at the very end, remained legitimately remorseful and upset about her own role, whatever that was, in the process. And she always maintained, even over our objections, she maintained publicly that I was guilty of voluntary manslaughter. I did participate in this crime, and it was a crime. And that was her view. And we sort of, at a certain point, well, we can't shut her up. That's her position. The instruction to the attorneys, to us, is that that's what she feels she's responsible for, so we're going to go with that. I think, if we'd had our druthers, we would have said, that's how, she's legally and factually innocent, there's no, but that was, so that kind of worked. I don't know.
I mean, I will say that it was a fascinating process for us as very junior lawyers to try and, again, to use the system in the way that we thought it was meant to be used and to advocate for her. And we went through a couple of different parole hearings, every time thinking that we had just a fantastic package, and then understanding that the parole hearing was in and of itself going to be used against Debbie in her habeas petition. So we began actually just waiving her parole hearings for a number of years for that very reason, because she had, in essence, to admit guilt, and then the DA would take that transcript and then put it and use it as evidence against her. And so we chose not to do that. Of course, in the end, you saw that we really had no other opportunity. The other thing that was interesting with the parole hearing, and you see again how the system is this sort of distorted thing that you have to constantly reshape. You know, in the system, Joshua mentioned that you have to be able to present evidence of battering, and they actually in California have investigators hired by the parole board who are supposed to be getting the evidence to then provide to the inmates that they can use to document mitigating circumstances. And we actually reached out to an investigator and said, can you help us? Because again, we were new, didn't understand. She said, absolutely, I'll help you. Let me show you how much I'm going to help you. She went out and did an investigation, and in her summary literally listed every myth that you see in folks discussing domestic violence. She had a job, therefore she could not have been abused, that sort of thing. So that was our first attempt. The second attempt, they were getting a little bit irritated with us, and so they decided on their own to initiate a second investigation. And that time they didn't actually go out and do any investigation. They just took our 13 declarations and tried to find inconsistencies. And they would do things like, this witness said they saw a bullwhip in the bedroom. This witness saw a bullwhip in the car. Therefore, there was no bullwhip. She's a liar.
That was an exactly pulled from the...
I mean, it was fascinating. And finally, one day, Joshua and I realized again that we were going to have to work around the system, not through it, to get her out. And we had this upcoming parole hearing, and we just were so irritated one day, we sent this really scathing letter saying, you know, we don't need we have a big firm, and we have 3 renowned expert witnesses who are going to testify, and, you know, that's wonderful for Debbie. We don't need you people, but we feel sorry for every other woman who's relying on your services, and you're doing this kind of just absolutely reprehensible work. And interestingly enough, again, the little angels in the system, somebody decided that they would again initiate a third investigation. And this time, the person initiated it pulled somebody out of retirement, and she came and did the investigation. And she went and spoke with our investigator, and he said, our files are open to you. Go and speak with whomever you want. We haven't paid anybody. We haven't gotten anybody to lie. And she came in with an incredibly strong supportive report. But it took that process again to get, as we say, kind of use the system, realize when it's not working, and create workarounds.
And can I just say, sort of jump, I mean, again, it's sort of what they don't teach you in law school. I mean, at our first parole hearing, I always remember I had to make the sort of closing arguments or whatever, and I kept being interrupted because this guard was smashing against the door of this tiny little chamber with chains over and over, like beating against the door with chains. And my voice started to crack because it was so hot and I was parched. And one of the commissioners paused the hearing and she said, "Oh, I have some water for you." And she came out, I kid you not, with a tiny styrofoam cup that had bite marks all around it and lipstick on it, with warm water from the bathroom, and said, "Here, this is," you know, and it was kind of like, I mean, it was like off color, you know, and I was, this is what you must do for your client, you know, like drinking this water and arguing, you know, it's just a very bizarre experience, and you know, we walked out of there thinking, man, you know, this is, how could they teach this in law? You know, you just don't know what the system is going to provide, you know, so.
One thing that I didn't understand from the film, how was it possible after the chief deputy DA signs the new plea agreement for the DA to then withdraw it? I mean, how does that happen? There was a plea deal.
Yeah.
She had repled. There was a sentence. There was an agreement that the sentence would be 6 years. How did the office withdraw that? How were they able to?
Well, they weren't. We always maintained that they weren't legally able to withdraw it. But what they made clear in their communication with the judge was, "Judge, you don't have to approve this deal. It's a trilateral deal in a sense. Just because the DA and the defense attorney agree doesn't mean the judge will endorse that disposition. And we hereby inform you that you should not enforce this deal because it was wrong and we never should have made it." And, you know, from what we were told, they also had a number of ex parte communications with the judge about it and explained, they had to go and they somehow explained to the judge that there had been this violation of their chain of command. We had gone over the head of the person who should have approved it, and therefore, which, again, we weren't privy to any of that. And the judge who summarily denied the petition, it was like, I don't know, it was like 13 pages or something, and we're reading this thing, and it didn't have anything to do with our case. And it said, a human life is sacred, and sort of all these random citations. And we called around to other defense attorneys or other sort of pro bono attorneys who are representing women through this same law, and we faxed each other or emailed each other copies of our summary denials, and they were identical. They hadn't even been tailored to match our case, and it was just the judge had just kind of, and we actually did a number of motions for reconsideration and rehearing on that petition, which were all sort of summarily denied. And we were told that the habeas petition is fundamentally a criminal proceeding in California, therefore the civil reconsideration statute couldn't apply, which was actually wrong. We had all these cases, there were Supreme Court cases that said in California the habeas proceeding is actually a civil proceeding, but whatever. It was just sort of this strange unwillingness by the court to uphold that agreement.
Did the DAs claim what is basic law? That is, the prosecutor can make a plea bargain offer in a normal case. This is anything but normal. And they can withdraw it at any time. Did they simply say, it's withdrawn?
Yeah.
And the other thing that I didn't understand from the movie, and I'll explain to our students in a moment, is the condition on the part of the, quote, plea to the voluntary manslaughter was that Ms. Peagler waive any civil claim she has against the DA. Was that part of the deal?
Well, so the sequence was essentially, they gave us the offer, we accepted the offer.
Meaning the letter comes.
The letter comes, we contacted the office, we say, we accept your offer, and we are putting, this was their instruction to us, was that we would put together a stipulated habeas petition. So it would actually have both of our captions on the pleading, and we would both sign it, saying, Judge, their terminology was, we're submitting this for a dispo, meaning a disposition, basically saying the parties have agreed, here's both of our signature blocks, there's no disagreement as to the relief that's being requested. We literally drafted that, sent it over. It came back with some red lines. We want you to do this and that, so they were sort of editing the document. Then we got a phone call. Oh, people are upset about this. Will you also waive her civil claims? After we had done and we basically just stayed silent on that. We also did research and discovered that, well, in California, you're not allowed to mix the two. Yeah, in California, there's a specific prohibition on holding out a civil waiver in return for a criminal, because that's coercive and there's different, you can't adequately represent your client or these kind of, so we were just sort of silent about that, and as we were silent about it, the whole thing kind of unraveled, and then we got this, it was unraveling, we got the sort of the call, take out all reference to our deal, but submit it and we'll just support it orally. Just go ahead and just submit it quickly and we'll support it orally, which we had a whole heartache about, do we do this, do we not do this? We really feel it's important that the judge know this, but we ended up sort of submitting the second red line, which omitted all of those references, and then they refused to support us.
The basic law, at least I can say in New York, is what I indicated earlier. That is, the district attorney can extend a plea bargain offer, but can withdraw it at any time. The more complicated question, which was not litigated in this case, is if the offer is withdrawn and it's done for, quote, some malevolent or vindictive reason, then it rises perhaps to the level of due process. To get there is a huge leap, because, again, the offer can be withdrawn at any moment until it's accepted. The other thing that's interesting is evidently we have similar laws. Nationally, the Supreme Court has sustained the use of civil releases in return for a, quote, beneficial plea. The case is Town of Newton versus Rumry. And that's a New Hampshire case. The Supreme Court said these requests for civil releases by prosecutors, they're valid nationally. In New York, we have the same law as here now in California. It's against the state court rules to engage in any request for a civil release because of the same notions that the DA really is not responsible for protecting the civil coffers of the municipality, and it's coercive, et cetera, et cetera. And so I'm old enough to have had that practice once upon a time in this state. It stopped here, I'm going to say, in the late 80s. And it literally stopped dead because our Court of Appeals said no more. So I guess my last question then is, do you think that the civil release is what tied it up, or there were bigger problems afoot? And it sounds like it's the latter, not the former.
Yeah, I certainly think, whatever we would have done, they would have continued to behave as they did, quite honestly. I think the LA County District Attorney's Office, I think, culturally has a number of issues that just prevented them from doing the right thing in this context. And as soon as they got themselves kind of backed up against a wall, they just dug in their heels and became, like I said, literally irrational in many, many respects. I mean, to this day, you saw the little clip with Steve Cooley, but that's still his position, that this was an assassination killing for hire, despite the fact that he actually was the one who sat down at a table in his conference room and said, how do we get this woman out? And none of the information changed. It was all politics.
Can I just take us back for a minute to 1983, and the plea is taken. As I understand it, the prosecutor says, we will seek the death penalty unless you agree to plead guilty to murder, and the sentence will be 25 to life. So what happens? What does her defense lawyer do? Did her defense lawyer do any investigation? Did the defense lawyer find out anything about Dead Man? And was that an issue at all that you were dealing with?
Her defense lawyer said, take the plea, otherwise you will be in the chair, period. It was a 15-minute conversation.
Yeah, her defense lawyer had unfortunately passed by the time we took the case, but we talked to a number of luminaries in the defense bar, and we talked about this guy. I don't want to unduly slander him, but we asked them, what did you know of him? What was his, and they said, well, the rumor was that he accepted a lot of drugs in lieu of representation, and he would have been hard to distinguish from his clients because he wore this kind of pimp fedora with like a huge feather on it. And he was in private practice, and when there was a conflict where the public defender was representing a defendant, which they were in this case, they were representing Ramon Sibley, the killer, Debbie was given this sort of contract alternate defender, who was this guy who took her case. And I mean, quite honestly, as we were reading the transcript, I've never seen this in the preliminary hearing, which is sort of like, I don't know what the New York, if you have this, but it's sort of the evidentiary hearing on whether there's probable cause to proceed with the prosecution. So at the preliminary hearing,
Books, but it's never done.
Her lawyer almost really elicited the worst testimony that came out of Dead Man was from her own lawyer on cross-examination. So she never told you that, well, yeah, she did, And at the end, the judge sort of had this admonishment. This testimony is very ambiguous, and quite frankly, I think the case is pretty poor, but there's just enough. I'm going to hold her over. The prosecution can continue. So he was really, it was really terrible, quite frankly. And we could have had an ineffective assistance of counsel claim probably thrown in with everything else. But, we had decided, and at this point, kind of our strategy was, we don't want to deflect. In the beginning, we didn't want to blame anyone because we were just, hey, there's a new law. This evidence was never supposed to be considered by anybody. There's no fault by anyone. We're all friends. Steve Cooley, we got the agreement. That was our direction. And then after that, as it began to unravel, we said, okay, fine. If we're going to blame someone, we're going to blame the DA. We don't want to mix messages by saying that, he was also, but he was quite frankly terrible. So, and that's something especially for those of you that go into appellate law, you kind of inherit the record that you get, and these are the cards you have, and we were given a tough set of cards.
So why was there no discussion, however? I know the editor of the film was here as well. Did you discuss whether you wanted to have some kind of discussion as part of the film about the defense lawyer and just what happened when that plea was taken and during the hearing?
I think that we might have, one of our editors, Levi Welton, is here, who's actually a Touro College student now. There were so many aspects of this case. We filed a motion for bail, for release on bail at one point. We did all these different tangents, and I think he just sort of felt that there were too many characters already, and he needed to just sort of strip it down and streamline it. The other thing was that he was, sort of, you can tell from the movie, he really liked kind of the live action, being there with real people talking, and because the guy had passed, he just felt that this wasn't, it would have had to be some kind of a recreation or his photo, which we didn't have, and he felt that it was sort of narratively weak. But we had to get his files out of someone like from a garage. It was like literally someone's garage in some suburb of LA where he had kept his files under a pile of dust, and we were able to find them. But
I will say as well that I think there was this sort of general notion that however bad he was, we never got the sense that he was doing anything nefarious. He was just incompetent in many ways. And when you looked at him compared to what we saw with the district attorney's office, both back then in the original prosecution and then how it was being handled now, we were so astonished about the sort of malevolence that we were receiving, that I think that was just naturally where the film continued to focus.
right, mere incompetence wasn't enough to raise our pulse.
Right. And we kept thinking, the prosecutors, yes, their job is to convict, but it is also to seek justice. And the fact that these prosecutors who had so much power, they had so much authority, and they had the opportunity, our whole goal initially was to give them the opportunity to do the right thing. And they had this perfect case kind of delivered to them. And for whatever reason, some of which we guess, some of which we'll probably never know, they've chosen to go an entirely different way. And we just kept saying, you guys have everything. This woman, these inmates, Debbie was shackled during her chemotherapy. They have nothing unless somebody else is advocating for them. And for the prosecutors to kind of continue to stack the decks, it just seemed reprehensible.
Natasha, your mother, of course, comes across as so utterly, amazingly inspirational on so many levels. Could you just speak a bit about maybe your visits with her in prison, how often they would occur, and what she was like, and did she have such little bitterness, and just what was going on?
I am grateful that the fact that my mom has passed and she has a legacy left on. Because it really does capture her true character. This is how she was. If she got discouraged, it was for a second, and she was, she had a bigger purpose. She felt like she needed to be there. God wasn't finished with her yet. She just really was a very positive person through it all. I got to see her a lot. We went and saw her maybe during the summers and stuff, and Christmas breaks and stuff like that when they could. The prison makes visitation so hard to the point where families normally get discouraged. But because of the type of person my mother was, because she was such an amazing person, she worked for she's worked for the ward of the prison and a lot of the high-end people, so it helped us during visitation. But I can see very easily how you can get discouraged and just kind of write off your family once they're incarcerated, because it's so they make it impossible to just to spend a couple of hours with her. It was very, very, very hard. But she was this film just captured who she was. She was an amazing, amazing person, and it's just I'm so grateful to these two for everything that they've done. It does make a difference. You can make a difference. And just doing what you're doing, going to law school, it starts with the simplest things, can really turn out to, as you see, to be something very rewarding.
If I can say something as well, you see how amazing Debbie is, and that comes through the film. But, her daughter is just like her. Tasha didn't just go and visit her randomly. She fought to be there. She moved to California to be closer to her mom. She advocated for her every single day. She was part of the legal team. She was working together to put a plan of action so that we could present it to the parole board, where they said, she is our family and this is what we will do should you allow her to be released. I mean, so Tasha and Carla, Debbie's sister, and other folks in her family were just incredible advocates, and we just felt very blessed to be a part of this wonderful women's very special family.
And I just want to say, I was have just sort of stepped down from my term on the Alameda County Bar Association, which is the county that has like Oakland and Berkeley, et cetera, on it. And, one of the things that we really try to do is encourage lawyers to do some pro bono work. We have like just do like 20 hours a year, it's a very low kind of target. And, the response is like, but, why would I want to do anything I'm not getting paid for? And the payment that you get by having this bond and this relationship with your client and your client's family. I mean, both of us like gained another family, or gained a bigger family, and it just the reward of being, even if we lost, unlike sometimes in a civil case, even if we lost, to come back and have them say, you're our heroes, you're amazing, I can't believe what you're doing. I mean, you just walk so tall. I didn't give money to homeless people for like 7 years because I felt that I was so, so honestly, I felt like, you just get, it's such a reward, and of course, there is something really special about advocacy for people who are in prison, that if you can get them out, this sense that you're like, this freedom, this human liberty is, like, I helped do that, and it is the most, for me at least, anecdotally, if you're talking to other folks who've done this, I mean, it's such an amazingly rewarding experience.
Yeah, perhaps just closing remarks, sort of going back to the first comments that I thought when you broke down, when you found out that she was out, there are just so many wonderful moments that someone has as a lawyer. They mean so much, and the work is so important, and in spite of all that you might be reading these days about too many lawyers, it just is a glorious occupation with just so much chance to really have incredibly important impact upon people's lives, as both of you certainly have done. So, thank you.
Well, I guess we'll each have, the thing that I like to say, which echoes what Nadia said, is that when we first started representing Debbie, we just graduated from law school, we were getting lots and lots of training in land use law. My joke about zoning you for an airport, my day job is I'm now in-house at an airport. That's really what we were doing. And we would go down, we'd be representing Debbie, and she would ask us basic questions about criminal law, criminal procedure. I was kicking myself that I didn't pay sufficient attention in the classes I had taken. Real basic stuff, and we don't know. And she was like, what do you mean you don't know how, like a plea bargain, what do you mean you don't know? And we're like, we don't know anything about this. And her joke was like, it's okay, there's no one else, I can't fire you. And we'd be like, whew. And she's like, don't worry, I won't fire you, and there's no one else. And then I think pretty quickly that concept of there's no one else began to be a really powerful kind of professional and spiritual motivation for us, because we realized there was truly no one else. Like, if we stopped representing her, it wasn't like there was a line of people that were going to step in to take her case. We were it. And I think that if you apply that, again, because you have this unique set of skills and training as lawyers, and just the ability to find out what the answers are, that if you take that philosophy that, some senior partner will handle this or some expert will handle this, they never will. You really will be the only person that's doing it, and there is no one else. And I think this has been set up here, the one virtue that I am proudest of us and our whole team about is perseverance. And we just had the sense of, darn it, we're not going to stop, we're not going to back down, we're not going to quit. And even if we don't know what we're doing, we have to be better than nobody. So we're going to stay with this case. And I think that for all of you, when you get out there, if you adopt that same attitude, you'll find that you will be successful, and you'll have very rewarding cases and clients and a lot of success.
And I think I guess I would just add that again, as law students and lawyers, we're highly focused on winning, and that's kind of the definition of success. And for us, what we had to also accept was that we ultimately did not control if she was ever let out of that prison. And so we had to help redefine what we viewed as success in some respects to get up in the morning. And I know for me, what was very, very important to understand finally was that whatever else we could or couldn't achieve, whatever failures we were going to have, in the end, what we did control was that we could show up every day and we could help her understand how much value she had in our hearts and in the world. I mean, she became an incredibly, incredibly important person to so many people, and she had always been a very important person to her family. And she never really understood any of that because nobody had ever bothered to ask her what happened. Nobody had ever bothered to tell her that she was worth advocating for. And so, for me, it just became critical to understand that as a lawyer, our job often is just to be there and to say, I'm going to be with you and we're going to work through it no matter what, and that you're worth that. And I think particularly for folks who are incarcerated and for many of the clients that you'll reach out to in the pro bono context, most of the time they're told that they don't matter, they don't exist, they're irrelevant. And by you just sitting there, writing something down on an intake form, spending time after class saying, I'm going to go get you that vacuum cleaner because I know you need that. Whatever it is, you've reached out to them and said, you do in fact matter. And that in and of itself can make a tremendous difference. So I just want to say thank you guys for being here. I mean, it matters so much to us to have people get to see Debbie. I mean, it's so uplifting for us to see people inspired by her, and for you guys to go out now and take on pro bono cases because of the legacy that she has left is just absolutely fantastic. And I know she's looking down right now and smiling at all of you. So thank you so much for being here.
Well, I just can't, on behalf of all of us, I just can't thank you enough for this really very special and extremely important evening for us. So really, thank the three of you.
Thank you.